can police force you to give your phone password? Imagine this, the police stop you, they take your phone, an officer says, unlock it, give us your password. You refuse. The officer says, if you have nothing to hide, why are you refusing? Now, the question is not whether you have something to hide, the question is much more fundamental. Can the state legally force you to reveal the password to your own phone? And the answer takes us straight into one of the most important protections in the Indian Constitution. Article 20, Clause 3. It says that no person accused of an offense shall be compelled to be a witness against himself. This is the constitutional protection against self incrimination. But here's where the modern problem begins. When the Constitution was framed, nobody had a smartphone. Today, your phone may contain your photographs, private conversations, emails, financial records, location history, medical information, work documents, passwords, and years of personal life. Your phone is no longer simply a device, it can be a digital extension of your identity. So, what happens when the police want access to it? Let's distinguish between two things. The first is physical evidence. The second is personal testimony. The law has traditionally treated them differently. If the police lawfully obtain a physical object, that does not necessarily mean Article 203 prevents them from using it as evidence. But compelling an accused person to communicate something from their own mind raises a different constitutional question. And that is where passwords become particularly interesting. A password is not merely a physical object, it is information known to you. It may exist only in your memory. If the state compels you to reveal that information, is it compelling you to provide evidence against yourself? That question becomes even more complicated when we talk about biometric authentication. Suppose instead of asking for your password, the police ask you to unlock the phone using your fingerprint or your face. Is that constitutionally equivalent to forcing you to disclose a password? Not necessarily. And this distinction matters. A fingerprint or facial characteristic is physical information. A password is knowledge. The Supreme Court's jurisprudence on self-incrimination, particularly in State of Bombay versus Kathikalu Ogad and later in Selvi versus State of Karnataka, has drawn important distinctions between physical evidence and testimonial compulsion. The principle emerging from this jurisprudence is that the Constitution is particularly concerned with compelling an accused person to communicate personal knowledge that can incriminate them. Now imagine the investigation is serious. The police suspect financial fraud. They believe evidence is stored inside your phone. They don't want your explanation. They want access. Can they simply say, give us the password? This is where another constitutional right enters the picture. Article 21. The right to life and personal liberty has been interpreted to include the right to privacy. The Supreme Court's decision in K.S. Puttaswamy was Union of India recognized privacy as a fundamental right, and digital privacy is now an unavoidable part of that discussion. Your phone can reveal who you communicate with, where you travel, what you read, what you believe, who you meet, what you buy, what you search. In other words, unlocking your phone may expose an extraordinary amount of personal information. But there is an important qualification. Privacy is not absolute. The state can interfere with privacy when there is lawful authority, a legitimate state purpose, and the constitutional requirements of necessity and proportionality are satisfied. So the answer is not simply police can never access your phone. That would be incorrect. The real legal question is, what is the lawful procedure for obtaining access? And can the state compel the accused personally to provide the key? That distinction is going to become increasingly important because our phones contain more evidence than almost anything else we possess. And as criminal investigations become increasingly digital, courts will have to balance two competing interests. On one side, the state's legitimate interest in investigating crime. On the other, the individual's right against compelled self-incrimination and unreasonable intrusion into privacy. And there is one final point that everyone should understand. Refusing to disclose a password does not automatically mean that a person is guilty. Suspicion is not proof, silence is not a confession. And exercising a constitutional protection cannot by itself be treated as evidence of guilt. The real constitutional challenge of the digital age is therefore not whether the police should investigate. Of course, they should. The question is how far the state can go in making you participate in your own prosecution. Because your phone may contain evidence, but it also contains something else, a digital record of your life. And the Constitution does not disappear simply because that life happens to be stored behind a password. The question for the courts in the coming years will be simple to ask but extremely difficult to answer. When the state asks you to unlock your phone, is it merely seeking evidence from you or is it compelling you to become a witness against yourself?